I'm not going to let you die here. I'm not going to let you squander this opportunity. I will stay on top of this until we get you going well. Because the way that you're going now, it sucks. It's not good.
Two defendants, two completely different cases. One judge who refuses to let them become statistics. First up, a man accused of terrorizing his ex-wife with threats and a cane. Then, a 20-year-old caught dancing in the street waving a loaded .45 caliber pistol, who then fought with police for 6 minutes while reaching for the gun. He's already on felony probation. One wrong move, and he's looking at a decade behind bars or a body bag. But what this judge does next, it's not what you'd expect. This is a masterclass in tough love, second chances, and the harsh realities of the justice system. Let's break it down.
You speak English, sir?
Yes, sir.
Good morning, gentlemen. How's jail?
Ain't fine.
Good. It's not supposed to be fun.
I'm disappointed. I wasn't even supposed to be there.
Let's talk. We'll figure out why. All right. Both of you guys have picked up criminal cases. You've not made bond, and you don't have anyone that's going to make a bond for you. That's why you're in there right now. Your lawyer is asking for me to give you either a PR bond or to lower your bond. And we're going to have a discussion now as to whether that's going to happen or not. I'm a firm believer that everybody should be given at least one chance to see whether they're going to do right or not. Right? So hold on. Just don't say anything yet. You'll get your chance, I promise.
Right off the bat, you can tell this judge is different. He opens with a powerful statement. I'm not going to let you die here. I'm not going to let you squander this opportunity. That's not standard judicial language. That's a man who sees beyond the charges and recognizes that these are human beings at crossroads. And then he asks, how's jail? One defendant says fine, and the judge immediately corrects him. It's not supposed to be fun. That's the balance this judge strikes. Compassion mixed with reality checks. He then lays out his philosophy clearly. I'm a firm believer that everybody should be given at least one chance to see whether they're going to do right or not. This sets the tone for everything that follows. These defendants are about to get their shot, but it comes with expectations. Let's see if they're ready to meet them.
Mr. Guerrero, let's start with you. So you're charged with terroristic threat. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Yes, Judge. On January 27, 2025, at 8:11 a.m., the officers arrived on the scene for a weapons disturbance at a residence in Harris County, Texas. The officers met with the complainant and a witness outside the residence and later met with the defendant inside the residence. The complainant stated the defendant, the ex-husband, lives with her at the house since last year. The complainant stated the defendant has threatened her numerous times and she was scared of what the defendant would do if she called the police. And on November 3rd, 2024, the defendant texted the complainant, I didn't put I'm fucking you up when you come back, bitch, but never assaulted the complainant. And in the middle of December 2024, the complainant was on the phone talking with a friend when the defendant approached the complainant from behind and tried to take her phone and shouted, asking who she was on the phone with. The defendant failed to get the phone away from the complainant. The complainant ran out of the residence out of fear. Around Christmas 2024, at approximately 7 to 8 p.m., the complainant and the defendant were arguing about the complainant's boyfriend having a key to her vehicle. The complainant and the defendant went to go get the keys, and the defendant stated, I'm going to kill him. The complainant was in fear, and the complainant's boyfriend did not want police called. On January 26, 2025, the defendant came out of his room and the complainant's jacket on the chair where the defendant's cane normally rests, and the defendant saw his cane laying on the floor, and the defendant accused the complainant of placing it there. The defendant followed the complainant into the kitchen and was close to her face. The defendant told her, you know I can hit you with this cane. I can hit you with this. Next time I will hit you. The defendant was waving the cane in her face as he said this, and the complainant was in fear of what the defendant may do to her. The defendant calmed down, so the complainant did not call the police. The complainant called the police the next morning because she wanted him out of the house. The witness, the son, corroborated the complainant's telling of events and stated the defendant said to the complainant, I could hit you if I want to, and was close to the complainant in the hallway and was waving the cane in the complainant's face.
Let's break down what we just heard about Mr. Guerrero's case. This is a pattern of escalating behavior. It starts in November 2024 with threatening text messages. I'm going to mess you up when you come back. Then in mid-December, he's grabbing at her phone, shouting at her, causing her to flee the residence in fear. Around Christmas, He threatens to kill her boyfriend. And finally, on January 26, he's waving a cane in her face, telling her, "I could hit you with this. Next time I will hit you." The son witnessed this and corroborated everything. Here's what makes the situation particularly dangerous. This is her ex-husband, and yet they're still living together. That a powder keg waiting to explode. The complainant didn't even call police until the next morning because she was too scared of what he might do. When someone is living in constant fear of their ex-partner, that's textbook domestic terrorism. The charge is appropriate, and this situation needs immediate intervention.
Guerrero, I'm going to find that there's probable cause to go forward with your case. The magistrate here did not give you a PR bond. If I give you a PR bond, I want assurances that you're not going to have contact with the complaining witness in this case. You're not going to have.
Daughter, she's gonna take me somewhere else.
That's it. 95% of the people that are in jail now because they have no self-control. They get upset and they wig out and do whatever they, without thinking, if I do this, what's going to happen? If I say this, what's going to happen? Would you like me to give you a PR bond?
Yes, sir.
I don't want you to have contact with the complaining witness in
I
the
won't.
case, sir. I don't want you to have any weapons, and I want you to have self-control. I've given you a lawyer. It is your responsibility to stay in touch with her. I'm giving you a chance now.
Yes.
Don't pick up any new cases and don't disappoint us.
No, sir.
You understand?
Yes, sir, I understand.
Um, do you mind filing those conditions that he's not to have contact with this person?
No weapons, Your Honor, as well.
No weapons, no contact. I am also entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Cortez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir, I understand.
If you have kids and they live with her, then use someone else. Don't call, don't go over there because you now know no one's going to bond you out. So if you end up going back to jail, you'll be stuck like Chuck.
Yes, sir.
You understand?
Yes, sir.
All right, man, I'm giving you a chance.
Okay.
Okay.
This is an important legal moment that many viewers might not fully understand. The judge just issued what's called a Magistrate's Order for Emergency Protection, or MOEP. This is a court order, not a suggestion. Let me break down what Mr. Guerrero just agreed to. He cannot commit any family violence or assault against Ms. Cortez. He cannot stalk her under Texas Penal Code Section 42.072. He cannot threaten or harass her, directly or through another person. He cannot possess any weapons. And he cannot go within 200 feet of where she lives or works. That's about 2/3 of a football field. The judge also drops a crucial reality check. No one's going to bond you out. So if you end up going back to jail, you'll be stuck like Chuck. Translation? This is your one shot. Violate this order, and you're sitting in a cell until your trial date. However long that takes, the stakes couldn't be higher.
Mr. Ellis, your case is quite a bit more complicated. You were charged with unlawful carrying of a weapon. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 29th, 2025, at approximately 3:29 p.m., the officer dispatched to a weapons disturbance call at 5900 Long Drive in Harris County, Texas. The officers were given a description of the defendant and that he was dancing, waving a gun. The officer arrived at the location and saw the defendant matching the description at a bus stop. The officers observed the handgun sticking out of the defendant's front right pocket, and the officers told the defendant to put his hands up, and the defendant continuously refused orders from the officers to let go of the firearm. The officers used force and pulled the defendant's arms away, and the defendant continued to grip the firearm, attempting to pull it out of his pocket. The officer was hit by the defendant while pulling away, and the officer was thrown into a metal and glass wall at a bus stop. The officer sustained minor abrasions to his right arm, and the officer struggled with the defendant for approximately 6 minutes until detaining him. The officer spoke with a witness who stated she was walking to work and heard and saw the defendant dancing and rapping while waving around a firearm multiple times.
And now we get to the case the judge warned was quite a bit more complicated. Listen to what happened here. Someone calls 911 to report a man dancing in the street while waving a gun. Officers arrive, see Mr. Ellis at a bus stop with a handgun sticking out of his pocket. They tell him to put his hands up. What does he do? He reaches for the gun. He grips it. He tries to pull out while officers are struggling with him. For 6 minutes, this altercation continues. An officer gets thrown into a metal and glass wall. Let me be absolutely clear. This is the kind of situation that ends with someone getting shot. Every single day in America, young men die in encounters exactly like this one. Mr. Ellis is incredibly fortunate to be standing in a courtroom instead of lying in a morgue. The judge is about to explain exactly why this case is so serious.
Mr. Ellis, let me read something to you. This is why the magistrate did not give you a PR bond in this case. Defendant on a 3-year deferred for a state jail felony since 3/21/24 allegedly stole CBD disposables. In this case, the witness called to report a man dancing around and waving a firearm in the air at the 5900 Long Drive in Houston, Texas. Law enforcement officers arrived, saw defendant matching the description as sitting at a bus stop, saw butt of gun sticking out of his pocket. Law enforcement officers told defendant to put his hands up. Defendant instead reached for his gun. Do you know how many people die from that very thing right there? Watch the news every single day in America. A young person dies just because of that very thing right there. Law enforcement officers struggled with the defendant as he continued to reach for the firearm, finally got him cuffed after approximately 6 minutes, then recovered a loaded .45 pistol from his pocket. One law enforcement officer injured during the struggle, pushed against the wall of the bus stop, sustained minor abrasions. Could have been another assault of a peace officer, which is a 3rd-degree felony, 2 to 10 in the penitentiary right there. Witness identified defendant as a person she saw dancing, rapping, pulling out a black pistol from his pants and waving it around multiple times, not obeying NFC of the deferred, the conditions of the deferred. Public safety concerns, indigent per AFC. This is the reason why you were not given a PR bond in this case. And quite frankly, Mr. Ellis, it scares me that if we let you out, what's going to happen? Sometimes we have to protect people from themselves because of their own worst enemy.
Let me explain just how much legal trouble Mr. Ellis is actually facing. He's already on a 3-year deferred adjudication for a state jail felony. That means he was given probation instead of prison time, with the understanding that if he stays clean, the conviction doesn't go on his record. But here's the thing about deferred adjudication. If you violate it, the judge can sentence you to the maximum penalty for the original offense. And now, he's picking up a new weapons charge while on that probation. The judge even points out that throwing the officer into the wall could have been charged as assault on a peace officer, a 3rd-degree felony carrying 2 to 10 years in prison. We're talking about potential decades of incarceration if this goes badly. And when the judge says it scares me, that's not rhetoric. He's genuinely worried about what happens if this 20-year-old walks out that door without intervention.
Counsel, what would you like?
I would like to get his bond lowered. He is staying with his mother. His mother will be able to, keep an eye out on him and make sure that he does abide by the conditions that was previously set. I will give her a call today. He's looking for work and he has a child on the way. We're just asking for a lower bond.
What do you do with yourself these days, Mr. Ellis?
I'm just looking for a job so I could take care of my family because right now I'm with a whole 36-year-old and I'm 20 years old and I'm taking care of her kids, her and myself. And I'm staying with my mom and I'm in and out with my baby. So it's a whole lot of stuff going on. And then even dealing with that third-degree
It's
felony
not,
charge.
I don't want to talk about the cases. My concern is that, Mr. Ellis, you're a baby yourself and now you got a kid on the way. How many kids you got?
To be my first, because I lost my first son at the age of 15, stillborn.
You were 15 when you had your first kid.
I will make contact with his mother, Your Honor, before I leave today. She's present in his life. Yeah.
What's going on with the deferred upstairs? Have they done anything? Have they filed a motion to revoke?
Let me see. It does not appear that at this time they filed a motion.
What do you guys think as far as a bond reduction? State.
Your Honor, based on the fact of the nature of him being a threat to the community and to the officer themselves, which are considered under 1750, and we request 5,000 would be.
I'm requesting 2,500, Judge. He's out of work and the person that would make bond for him would be his mother. And
How long has he been on probation? He's been on probation for a year. He's already had one BVR. You know, when you're on felony probation, you're supposed to live like you have a halo above your head because you're really looking at a lot of time in prison. And the way things are going now, this is not a good way to go. You're going to end up either dead, in prison. It's hard enough in this society as a black or brown person. All you're doing is making it more difficult. The older you get, the more difficult life gets. And if you don't have a skill, a trade, knowledge, you're going to end up with a 40-year sentence or in a gutter, begging, because life sucks without money.
This moment right here is why this video matters. Listen to what this judge just said. Really listen. It's hard enough in a society as a black or brown person. All you're doing is making it more difficult. That a judge acknowledging systemic reality while still holding this young man accountable. And then comes the brutal truth. The older you get, the more difficult life gets. If you don't have a skill, a trade, knowledge, you're going to end up with a 40-year sentence or in a gutter begging. He's not being cruel. He's painting the exact picture of where this road leads. And the tragedy? Mr. Ellis is only 20 years old. He lost his first child, stillborn, when he was just 15. He's caring for a 36-year-old girlfriend and her kids while unemployed. This kid is drowning, and without intervention, he will become another statistic. The judge sees it. Now the question is, can Mr. Ellis see it too?
And what you're doing now, all you're doing is you're making life even just the more difficult as it is. The more convictions you get, the more unemployable you get. If you don't believe me, when you go back there in the pods, ask. All the old timers that are in there, ask. You're 20. Don't squander your opportunity. I'll give you a bond reduction. I'll set it to 10,000 now.
okay,
I'd like to have contact with mom. So
okay,
somehow if you can like arrange so we can figure out how we can get through to Mr. Ellis.
yes,
So what we can do to, I'm not opposed to a PR bond,
Okay.
but I want to know that somehow we have some kind of structure in place so that we know.
okay, Judge. I will call her today. How would you like me to get back in contact?
I'm assuming he might go to felony court Monday. We can roll it to Monday
Okay,
and then just stay in the loop with me and then
Will
we'll
do.
structure things so that we can try to get him on the up and up.
okay. Thank you, Judge.
I'm not going to let you die here. I'm not going to let you squander this opportunity. I will stay on top of this until we get you going well, because the way that you're going now, it sucks. It's not good. You're not to use any weed. You're not to use any alcohol. And I'm going to stay on top to make sure. I'm giving you a curfew. I'm going to do all these conditions to make sure you're not going to end up another statistic. Do you understand? So we're gonna roll your case to Monday because I want to see if we can get your mom involved in this, see where we can go. Okay? All right,
Thank you, Judge.
thanks.
What an incredible hearing. Let's recap what we just witnessed. Two very different cases, but one consistent judicial philosophy: tough love, accountability, and second chances. Mr. Guerrero was charged with terroristic threat after months of escalating behavior toward his ex-wife, threatening texts, grabbing at her phone, threatening to kill her boyfriend, and finally waving a cane in her face, saying, "Next time I will hit you." The judge found probable cause, granted him a PR bond, but loaded it with conditions: no contact with the victim, no weapons, and a magistrate's order for emergency protection under Texas law. The message was clear: one violation, and he's stuck like Chuck. Mr. Ellis presented a far more dangerous scenario. This 20-year-old, already on deferred adjudication for a state jail felony, was caught dancing in the street waving a loaded .45 caliber pistol. When police arrived and told him to put his hands up, he reached for the gun instead. He struggled with officers for 6 minutes, throwing one into a wall. The judge laid out the stakes. This behavior gets young men killed every day in America. But instead of just denying bond, this judge did something remarkable. He reduced the bond to $10,000, committed to coordinating with Mr. Ellis's mother, and promised to create a structure of support around him. "I'm not going to let you die here," he said. "I'm not going to let you squander this opportunity." The conditions? No weed, no alcohol, a curfew, and a return to court Monday to establish a plan with family involvement. The judge even tells him to go ask the old-timers in the pods where this road leads. This is what justice with compassion looks like: holding people accountable while refusing to give up on them. Both defendants got their chance. Now it's on them to prove they deserve it. So what do you think? Did these defendants deserve second chances? Should the judge have been harder on Mr. Ellis given the danger of his situation? Drop your thoughts in the comments. We want to hear from you. If this breakdown opened your eyes to how the justice system really works, smash that like button and share this video with someone who needs to see it. Subscribe to our channel and hit that notification bell so you never miss another powerful courtroom breakdown. We'll see you in the next one. Stay safe out there.